Suppose you're driving down the road obeying the law, but you see those flashing lights in the rearview mirror and you get pulled over. But suppose the officer who stopped you thought your conduct was illegal, but was actually wrong about the law. And what if that led to a search and then an arrest? Would they still be valid? That's a question for the U.S. Supreme Court in its first case of the new term. It happened in North Carolina to Nicholas Hyen, pulled over on I-77 by a county sheriff's deputy because one of his brake lights was out. After getting permission to search the car, the deputy found a baggie of cocaine and Hyen was charged with drug trafficking. But it turns out North Carolina doesn't require cars to have two brake lights. The state law says they must have, quote, a stoplight on the rear, and elsewhere refers to the stop lamp. So the deputy was wrong about the law, but does that mean the arrest was invalid? It's an important question because traffic stops are the most common reason for coming into contact with the law. Nearly 20 million people pulled over a year. Nicholas Hyen's lawyer, backed by civil liberties groups, says if a law is not being broken, there's no authority to make an arrest or conduct any search that follows. And they say the courts can't hold citizens to the time-honored rule that ignorance of the law is no excuse, but uphold arrests by police who don't know the law. The Bill of Rights bars unreasonable searches and seizures, and courts have upheld arrests even when police make mistakes about the facts of what happened as long as the officer's observations were reasonable. North Carolina, backed by the Obama administration, says laws are sometimes complex or ambiguous, so police must have some leeway to make arrests if they reasonably think a law is being broken. The nation's courts are sharply divided on this issue, though most say if the officer is wrong, the arrest doesn't count. Now the Supreme Court will have the last word.